All right, good evening. This is a call to order for the April 13th, 2026 City of Canal, Winchester Planning and Zoning meeting. Ms. Gooden, roll call, please.
Mr. Ritchie.
Yes.
Mr. Wildenthaler. Mr. Donahue.
Present.
Ms. Gooden here. Ms. McDonald.
Here.
Mr. Deeds. Mr. Paulsgrove.
Yes. I move we excuse Mr. Wildenthaler and Mr. Deeds.
Second.
Okay, motion made by Mr. Ritchie, second by Mr. Paulsgrove. Roll call.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes.
Okay, so there's a clerical error in the agenda, so we need approval of the March 9th minutes.
So moved.
Second.
Any further discussion? Roll call.
Mr. Ritchie.
Approved.
Mr. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes.
All right, so now it's time for public comment for any items that are not on our agenda. Okay, if you'll be speaking with this evening, if there's any chance you'll speak to the commission, if you're able, could you please stand and take an oath? You don't plan to speak, sir?
Well, yeah, I'm speaking on behalf of my client.
Okay, so do you swear to tell the truth and in the testimony that you give and nothing but the truth? If so, please say, "I do." Thank you. And I would also remind members of the public and the applicants that there are 5 commissioners here this evening, so per city statute, any vote that we take has to have 4 positive votes. So if something is voted 3-2, it does not carry. So there's 2 commissioners that aren't here this evening. So just want to make sure everybody knows that. And now I'll turn it over to our city solicitor for the first application, which we have an appeal on our agenda this evening.
So the first application, or the first item on tonight's agenda is an appeal by Express Wash Concepts LLC for location at 9875 Greengate Boulevard. The applicant is requesting an appeal to the Planning and Zoning Commission on the Planning and Zoning Administrator's determination of prohibited uses for the subject property. Provided here from the Fairfield County Auditor's website, the parcel in question, which is located in Greengate Plaza. This applicant is appealing the letter on the left that was issued by the Planning and Zoning Administrator on February 17th, determining that the application for a car wash, which is indicated on the right, is a prohibited use based off the Valley Point Overlay District, Chapter 1175.02, subsection F1C. The applicant's here to discuss their appeal with the Planning and Zoning Commission. After their discussion, if there's any questions for myself or the applicant, I think would be the time to ask them.
Thank you. Anything you wish to add?
Yeah, I think I'll just give the commission a little context since we don't do administrative appeals all that often. So this administrative appeal arises under Code Section 1135.04 and 1137.07. The appellant has put forth 2 separate arguments that I expect they will discuss here. First, that the zoning administrator lacks the authority to effectively deny a final development plan for zoning concerns. And second, that the zoning administrator's zoning analysis is incorrect. Put another way, that the appellant argues that a car wash is not a prohibited use in the applicable property. The law department believes that it's not necessary tonight to address the first question head on. Instead recommends that the commission abstain from deciding that first question and address only the second question regarding the zoning analysis. Any motions in an administrative appeal are a little bit quirky as far as your final vote, so I just want to lay that out as well. We recommend the following motion in the affirmative. I move to grant the administrative appeal. Voting yes on the motion indicates that the appeal has merit and that the zoning administrator's decision was incorrect. Voting no on the motion would indicate that the zoning administrator's determination was correct and that the appeal lacks merit. If the commission votes to grant the appeal, then the appellant's full submission for a final development plan would be heard at the next meeting of this commission. And if the commission votes to not grant the appeal, then the appeal can be appealed again to City Council.
So can you clarify for the commission that, as you indicated, number 1 and 2, the authority of the zoning administrator, the city staff zoning administrator, and then the zoning analysis, why would we only focus on one of those?
Well, the short version is the law department believes that there might have been some confusion with the denial itself, and that practically speaking, the zoning administrator was addressing a certificate of zoning approval, but that might not be a proper question under this part of the code. So to address the merits of the underlying zoning concern, that's a question that will be before the board either tonight or in a month, regardless of the approach that you take here tonight. So to give the appellant an opportunity to continue working through this quickly, we recommend addressing the heart of this question about the underlying zoning question tonight.
Thank you. All right, I will now turn it over to the applicant for your presentation, sir. And if you could just state your name for the record and sign in, please.
Good evening. My name is Michael Friedman. I'm with the law firm of Robbins, Kelly, Patterson, and Tucker, and I am here tonight on behalf of the applicant, Treemangeshi LLC, or excuse me, the owner, Treemangeshi LLC, as well as the applicant, Express Wash Concepts LLC. The question before this body is rather simple. Are car washes a permitted use of the property? The answer is yes. It's very straightforward. But I would like to speak on what the solicitor indicated, kind of 2 preliminary questions before we get into the heart of that argument. First of all, in our notice of appeal, we did argue that the zoning administrator lacked the authority to issue the denial of the final plan submission. For purposes of tonight's discussion, I'll give a brief summary of that argument, but to the solicitor's point, we're here tonight, so I would just reserve that argument and preserve it, and just incorporate the arguments that were in our notice of appeal. The short version of that argument is that the code is pretty explicit that final plan submissions are to be submitted and sent to this body for review and approval or denial. There's nothing within the code that gives the zoning administrator the authority to deny a final plan submission. It shall be the duty of the Planning and Zoning Commission to review the plan and determine whether it complies with the regulations of this chapter. That's from section 1173.06B3 of the Canal Winchester Code. So we believe that Administrator Moore exceeded his authority by denying the plan submission. And part of the problem with that is that it only delays this. So if the solicitor is correct and this board were to grant the appeal, as the solicitor indicated, it would then come back before the board. This is just an added step that should not be in it. This board should be deciding the actual plan and reviewing and approving that plan. Again, I preserve that that argument for future use, and we just incorporate the arguments within our notice of appeal. The second kind of introductory issue here is it's important to note that the zoning administrator's denial, if it's classified as that, was based on one singular point, and that is that the proposed use for a standalone car wash facility is listed in the Violet Point Overlay District as a prohibited use. That was the only reason that the plan was denied. There were no other, for example, issues with the application fee or any of the attachments. There was no suggestion that there was any other violation other than the zoning administrator determining that the Violet Point Overlay District applied to the subject property, and that the fact that car washes are a prohibited use within Violet Point means that they are prohibited use for this subject property located at 9875 Greengate Boulevard. So turning now to the heart of the argument, the zoning administrator is simply incorrect in this interpretation. Green Gates itself was established around 2001 when approximately 300-acre tract of land was transferred, and Canal Winchester decided to add a zoning restriction text, we'll call it the Green Gates text, to cover the restrictions in land use, zoning restrictions on that large tract of land, so that future transfers and development would all be subject to that Green Gates text. Importantly, the law department last year provided, I believe, both this board and city council, I think through Administrator Moore, with a legal opinion that dictated how the Green Gates text was to be interpreted in the context of the larger zoning code. And the determination, and one in which the interpretation that I believe this board and city council has followed, is that Green Gates is a zoning text in and of itself, and that applies to the Green Gates property. And we agree with that. The subject property is located within the planned commercial district of the Green Gates area. The planned commercial district, there were 3 separate districts that were established by the Green Gates text, and this property is in the planned commercial district. The Green Gates text sets out specific uses that are permitted by right within that planned commercial district. And those uses are any that are permitted by right or conditionally permitted in the Canal Winchester zoning code as it existed through Ordinance 41-01. So as it existed in 2001. It's very important here. And we're going to get through a lot of different zoning texts, but there are kind of some principles that are important and that words have meaning. The Green Gates text itself, in a part of the preamble, indicates that references to this zoning code are specifically references to the zoning code as existed in 2001, 41-01 ordinance authorizing. That's important because while the zoning code may be amended and changed in the future, for the purposes of Green Gates, the uses are established through the references to the 2001 zoning code. I kind of think of it like an addendum to that Green Gates text, in that they could list out all the uses that were permitted conditionally or by right, but instead they said the uses that are over here in the 2001 text, those are the uses that are permitted by right. Specifically included in that 2001 zoning text within the general commercial district, car washes are a conditionally permitted use. As such, under the plain text of the Green Gates text, car washes are a permitted use within Green Gates. The analysis stops there. It's very, very simple. That's all you need to know. Car washes, being conditionally permitted in general commercial within the 2001 code, are permitted by right in Green Gates, and therefore are permitted use by right of the subject property. Unfortunately, the zoning administrator is injected the violet point overlay district as a means of indicating that the use is prohibited. The problem with this is that the Violet Point Overlay District was enacted in 2012, and the applicability section of that code indicates that, requirements and standards of the Violet Point Overlay District shall supersede other applicable sections of this zoning code in instances which similar requirements and standards conflict. That's section 1175.02B of the Canal Winchester zoning code. This is important, again, because of the use of the language, this zoning code. And the legal memorandum that this board and the city council has relied on has indicated that the use of this zoning code within the code references the Canal Winchester code. It does not reference other zoning texts such as the Green Gates text. Therefore, in terms of applicability of the Violet Point zoning code, or Violet Point Overlay District, the requirements and standards do not supersede the Green Gates text. If the legislature had intended that to be the case, they would have said this code and other zoning text, or the Green Gates text. They didn't. So therefore, Green Gates text remains intact and is not impacted by Violet Point. Another suggestion has been that the general conflict provision of the overlay district would conflict, and therefore the overlay district controls. Once again, the problem with this is that the overlay district section that was instituted, 1175.06, it discusses conflicts, and it says in cases where the requirement standards of the overlay district conflicts with similar requirements and standards of the underlying zoning district, the overlay district shall supersede such underlying zoning district. Once again, the problem here is that it's referring to the underlying district that exists in the code. It's not referring to the district as it relates to the Green Gates text. So the fact that any underlying district may have been changed does not impact Green Gates text unless there's actually amended. Again, this is not to suggest that Green Gates remains intact forever and can never be amended. What it stands for is that if the legislature is going to amend the Green Gates text, it actually has to amend the Green Gates text. It can't amend some other code provision and say, well, it relates through this and that and the other. No, Green Gates is its own separate text. It could use broad language saying any zoning text. It didn't. They're very specific with the language. And the underlying districts relate to the district that exists at the time. They don't relate to the 2001 list of districts. So, for example, if they said the overlay district conflicts with similar requirements in past zoning codes, that might, but it wouldn't even impact Green Gates, once again. But if it did, it would relate back in time, but it doesn't. Green Gates text is a living, breathing document that controls the subject property and the property within Green Gates. And again, this is an interpretation that's been shared by the city and advanced by the city. In fact, Exhibit 12 of our letter is an email from Administrator Moore saying, here's a legal memorandum. This is how we kind of interpret the text and what applies. And it's clear that Green Gates applies to the property. Now, if there are instances where it doesn't answer all the questions or there are gaps, maybe Violet Point can fill in some of those gaps. But in this case, car washes were explicitly, conditionally permitted in 2001. As such, in Green Gates text, they're permitted by right. So not only does Violet Point not apply, but there isn't any general conflict. Green Gates applies. But even if you were to suggest that my interpretation is flawed or our interpretation is flawed, if there's any ambiguity that you find, it must be weighed in favor of the property owner. That's Ohio law. Ohio law says you've got to take the least restrictive means. Land use interest or restrictions are in derogation of the common law. And you're taking away an individual's private property rights. In order to do that, you've got to play by the rules. And you can't zone by implication. Governments are held to the words within their code, and they're strictly held to those. So if there's any ambiguity, the baseball saying is the tie goes to the runner. Well, in the zoning context, the tie goes to the property owner. So, even if you don't think that it's as clear as I'm suggesting to you tonight, the fact that there may be another interpretation offered by the zoning administrator based on this code would suggest at the bare minimum there's ambiguity. And if that's the case, it must be weighed in favor of the property owner. I don't want to belabor the point, but the final point I would make is that the property owner has been working in good faith with the city and wants to develop the land to make a good use and a profitable use for the city. Has been led down the road to believe that this is how it should be interpreted, relied on that interpretation. The plain interpretation is that the Green Gates text applies and car washes are permitted by right. Based on that, proceeded at the property owner's expense and the applicant's expense to advance this project, and now is facing pushback from the city saying, no, you can't do it. It doesn't make any sense. The most logical explanation is that the Green Gates text applies and that car washes are permitted use. So ultimately, we would request that this board overturn the decision of the zoning administrator and find that car washes are a permitted use by right within the Green Gates planned commercial district and as applied to this particular property. I believe, maybe I'm wrong, but everybody was provided a packet tonight with the notice of appeal and all of the exhibits. So I would just, everybody's shaking their head. I do have a hard copy I can enter, provide tonight, but I would just request that that formally be entered into the record. It's a lot of pages. I thought maybe best not to print out as many copies for everybody tonight. But I would ask that it be entered into the record, the notice of appeal and all 12 exhibits. With that, I'm happy to answer any questions and follow-ups, but I thank you for your time.
Thank you. What questions for Mr. Friedman? I'm sorry, sir, I didn't catch I couldn't write quick enough. Your first name?
Michael.
Michael, thank you. So I'd just say from my standpoint, I did really try to read through all of the submission, which was, I believe, 300-plus pages. And some of the questions that I have in my mind are, the order of operations in terms of the 2001 zoning code as it relates to the Green Gates text, as it relates to the Violet Point Overlay District, and who has authority and kind of what supersedes or doesn't supersede. So some of the clarification that you offered is helpful, so thank you. I do think I think we're here to vote on the zoning analysis and does it fit the code. And so while I don't have a specific question based on your presentation, Mr. Friedman, I would be curious to see if our solicitor has any other rebuttals or information based on their presentation that you haven't already shared, sir.
Andrew, would you like to weigh in at all?
Going through the applicant's appeal, and I have it pulled up here, I'm going to try to help you guys find pages in this text. So if you wouldn't mind skipping to exhibit number, give me a second, let me find it again. Sorry, the whole 2001 zoning code was copied in here, so it's a little much to scroll through quickly. Michael, which chapter has the Violet Point overlay?
The Violet Point?
Operations?
Yeah, I can,
I'm-
should be
I'm just-
11.
I'm on PDF page 111 here, and I think I've missed it already.
I think it's 1175. I think,
If you go to page 84 in your document, that has the memorandum from Frost Brown Todd. This memorandum was created for the Kroger's project when they were doing their preliminary development plan for the Green Gate Plaza area. This memorandum was created when there was an issue that was discovered between Planning and Zoning Commission's review of that preliminary development plan and City Council's review for that recommendation from Planning and Zoning Commission, basically uncovering that there were sections of the Violet Point Overlay District that have not been applied by the applicant Kroger's. If you skip to sheet, or PDF page 86, that has a zoning hierarchy. That zoning hierarchy discusses the 4 points for how all the development text overlays and PUD coincide together. The first is the Green Gates text contains specific zoning standards for a particular situation. Then the standards set forth in the Green Gate text controls. Next in the hierarchy is that the green text does not contain specific standards for a particular situation. The city must look at the overlay. The third is that the overlay district contains specific standards for a particular situation or fills in gaps in the green gate text in the overlay district controls. And the fourth is the Violet Point overlay district does not contain a specific zoning standard for the particular situation. And the city must look at current code, which controls anything remaining. In this scenario, the overlay district for hierarchy 2 and 3 is what sets the prohibited uses. So in the 2001 zoning code, there were no prohibited use sections in any of the code sections that were related to the Green Gates adoption. The Violet Point overlay district created those prohibited use lists, which specifically call out uses that are not to be permitted within this overlay district. This site is within the Violet Point overlay district itself. So creates that threshold for the standalone car washes to be a prohibited use, which is not found present in the 2001 code. Additionally, when looking at some of the comments the applicant made, just for some corrections, the CETA district was established in 2001 prior to the Green Gates text being adopted. That CETA district was a guiding document that didn't have any zoning text related to it. It was a joint cooperation between Violet Township and the city of Canal, Winchester for development growth within the corridor. In 2005, Violet Township and Canal, Winchester both simultaneously codified ordinances that had mirrored standards. And that time frame is when the majority of what you see in the current 1175 exists, was created, and then in 2012 it was amended. So I know the applicant said the CETA standards and overlay didn't exist till 2012. Just a couple clarifications on that point. I don't really have any other comments related to this other than the applicant submitted for a final development plan. When you look at chapter 1173, the basis for review, it says that the plan is complete in all respects related to the requirements set forth in the preliminary development plan submittal. And the first criteria of the preliminary development plan submittal is that the development plan is consistent with the purpose, intent, and applicable standards of the zoning code. So the applicant's submittal was not applicable to the standards of the zoning code, so that's why it was rejected because of the prohibited use.
And where would the prohibited use be located in these different zoning texts? So the 2001 zoning text, the Green Gate zoning text, and the Violet Oak.
So if you scroll up to PDF page 70 in the applicant's appeal, they have copied a modified version of the overlay district standards. This overlay district standards text, the applicant noted, was put together before Planning and Zoning Commission and City Council in reference to the memorandum to the Kroger preliminary development plan. That is also incorrect. This overlay district highlighted document was created by staff for the developer of Kroger to help them organize their site plan, as the preliminary development plan was not in compliance with the overlay district. So this attachment was put together for staff for the Kroger project specifically as it relates to their development pattern. It wasn't a supplement to that memorandum for explaining like everything that applied to the entire Green Gate district. A way to just show that visually is the Green Gates district includes planned commercial district, planned industrial district, and planned residential district. This highlighted document has very selective areas highlighted by staff for just PCD, again, for the simple conversation of Kroger understanding the text and for council to understand what staff was informing Kroger. It was not meant to be all-inclusive for the entirety of this Green Gates property, which is 300 some acres, which includes all of the Myers out parcels and developments as well, along with the applicant's properties. So as you go through the highlighted document, This is the only copy the applicant provided. They didn't provide an unredacted or unedited version in their appeal. The prohibited use list is on page 74. Under office and commercial standards, subsection F1C is prohibited use list. So there's the lists that are within here that are prohibited within the PCD zoning district. But again, for complete clarity, this document is not meant for the entire Green Gates 300 plus acres, or else there'd be a lot more highlighted through it. It was an effort to help Kroger and City Council understand what changes were being made to Kroger's plan and why.
So under the conditional use section, that all use is conditionally permitted in an underlying zoning district contained in this zoning code, except the prohibited uses listed below, shall be conditionally permitted.
Correct.
So talk to me about that.
So that conditional use section is saying that if it's a prohibited use, it is not even conditionally permitted. That was the reference that staff was referencing with the denial letter of the application.
So if you were referencing this, but this was only for the Kroger development text, how can we reference that?
So chapter 1175 is not for just the Kroger development text. What the applicant has inserted in their appeal is a reference from the Kroger project that was on City Council's agenda.
Okay.
They did not provide the current chapter 1175 in its entirety, just what was a part of another public bodies packet.
But the text is the same.
Okay.
I would agree. I think the text is the same, but I don't think it matters, quite frankly. Again, the applicability section in 1175.02 says the requirements and standards of the Violet Point Overlay District shall supersede other applicable sections of this zoning code in instances which similar requirements and standards conflict. So the prohibitions that came in through the Violet Point Overlay District in 2012 inserted prohibitions on property, but it didn't amend the Green Gates text. And again, that's the problem, is that the Green Gates text, to the extent it references the code, references the 2001 code, but that's only to grab in certain things, like the definition of what's a permitted use or a conditionally permitted use. Those that existed in 2001 come over, and therefore in Green Gates, Green Gates lives and breathes, those are the uses that are described. So in order to amend that or to prohibit those, that Green Gates text must be amended or to provide for those prohibitions. So the fact that the Violet Point Overlay District came into effect in 2012 does not change the fact that the applicability section says that it's this zoning code. It does not reference Green Gates. So Violet Point Overlay District, to the extent that there are gaps or whatnot, yeah, it may fill in. But in this specific instance, car washes were conditionally permitted in 2001. And therefore, they are permitted by right under the Green Gates text. If they wanted to change that and prohibit something, they needed to amend the Green Gates text. They did not do so. As such, Green Gates still applies. And I would agree that, I'm sorry if I misspoke, I understand the 2005 amendment added in the overlay district. It added in general overlay districts. Violet Point was then an amendment to add that specific overlay district. But again, the zoning underlying districts that are referenced in that conflict provision of the overlay districts relate to the underlying district. It doesn't change the fact that the Green Gates text applies and controls, and the references to the uses are those which were permitted or conditionally permitted in 2001. So again, without amending the Green Gates text, the fact that they amended other sections of the code, it does not matter. It's the same to say that if they amended the residential district of the underlying code, and they said any conflicts between this change and a previous version of the residential, or of this district, or this section of the code, this applies. Well, that doesn't apply to the commercial district. So when they amend the code to say it supersedes other applicable sections of this zoning code. They're specific in that language, and they have to be held by that. And Ohio law requires that the city be held to the specific language. Once again, cities cannot zone by implication. So I understand that maybe it was the intention or that their design that this applied to green gates, but the fact of the matter is the plain language of the code does not apply to green gates. It did not amend green gates. It did not change any of the uses of green gates. If they had intended to do so, they would have used that exact phrase, green gates text, or all zoning text. They were very specific in their language saying this zoning code. Cities and governments in Ohio are held to that language. And property owners are given the benefit of the doubt. Quite frankly, the fact that we're going through this much examination, cross-referencing of 4 different zoning texts over 25 years, would at the bare minimum suggest that there may be some ambiguity. Quite frankly, the interpretation we've offered is the easiest, most straightforward interpretation of this that makes sense. Otherwise, you're constantly referencing back and forth to see what may or may not be in existence. As we've presented it, the green gates text exists. Until it's amended, it exists, and those rights are the ones that are established through that text. So again, I believe that the straightforward, most direct analysis of this is that car washes are a permitted use within the planned commercial district of Green Gates, and Green Gates applies. And if there is any ambiguity, it should be weighed in preference of the property owner. So,
I have a few questions.
Please.
I have a few questions, I think, for staff or legal. When the development plan for Kroger's was identified and you did the development, the plan development, did it specifically say what was going to go in those other areas, or did it only identify where Kroger's was going to go?
The preliminary development plan by Kroger only identified Kroger from the initial concept through their final development plan. It provided an outlot for a fuel center, and then 3 additional outlots that would be retained by the current property owner.
And those outlots would be zoned the way we're talking about here, correct?
Correct. So the Kroger property, the fuel center, and all 3 outlots all have the same base zoning text references and the overlay applicability to them.
Okay, so a car wash was not identified in the Kroger plan
Correct.
at that time. And the applicant has said that they've submitted a final development plan, but when did they submit a preliminary for review?
So the preliminary development plan was done through Kroger identifying the outlot. A preliminary development plan is creating the base zoning text and standards and identifying the properties that will be served. The final development plan, in this case, is the appropriate path for the outlots to be developed on. Another way to think about it is if Kroger was not the one leading the application for the preliminary development plan, the property owner could have applied for the exact same principles. There just would not have been like a clear vision of, in this case, what the anchor of the plaza was going to be.
So, okay, it's my understanding that you can have, I call them bubbles, if you will. Here's a little bubble of these 3 out parcels that can be developed in the future. And we want one to be industrial, one to be residential, one to be commercial, correct? But we don't really know who's going there, correct? When Kroger did the development plan, did they say we wanted a car wash here?
They did not identify what any of the outlots were going to be.
Okay, so there was no preconceived idea of what was going to go in those parcels.
Correct.
So I go back to the final development plan. If we have not, as a board, looked at a development for a car wash in that as a preliminary, would that have been the first step?
No, so another way to think about it, Ms. McDonald, is when the Grand Gates development was zoned in 2001, the property owner had no idea of how any of the parcels were going to develop. So a master plan was created showing how out of that 300 acres, how they're going to do zoning. And that zoning set really based standards that would later be subject to review. So when a zoning area is going to be proposed for development, then a preliminary development plan gets submitted. And that preliminary development plan shows a little more detail for like access, lots, lot configuration, confirms any additional standards the applicant wants to set in place, and confirms that their development will meet the minimum standards the city already has in place. The final development plan would be for the individual outlots to be developed on it. So if you reference like the projects that this board has recently looked at in front of Myers, those were all final development plans because Myers created the pattern book and created the outlaw matrix for how it would be developed. That Meyer outlaw matrix didn't commit that one was going to be a McDonald's, but a McDonald's has the right to apply if it's a permitted use. So in this order, any of the outlots can be developed with a final development plan submittal.
Okay, and the final development plan was March of this year, March 2006?
For
Is that
Kroger's,
right? No, for the car wash
the applicant submitted the final development plan in February.
in February. Okay. So the next question I have, which may be a legal question, is the zoning code that is in place at the time of the application for the person who wants to occupy that space, isn't that what you review?
So the applicant explained it, that this is a very muddy code. The development text refers to the 2001 code, but the 2001 code doesn't include as many standards as current codes in overlay districts. So that memo from our legal department talks about the order when new language is inserted, how it's relevant. One of the things the applicant did mention was that, the city did not intentionally create standards or did not intentionally want the Violet Point Overlay District to supersede any plan districts. That is something that staff and members from our legal team have actually concluded that it was done on purpose. The overlay district was done to create this additional threshold, specifically when looking at the office and commercial standards. And again, I'm going to reference items that are in the applicant's submittal. If you go to PDF page 74, this is subsection F, office and commercial standards. It states the following standards shall apply to properties in the Violet Point Overlay District zoned general commercial, neighborhood commercial, suburban office, institutional, exceptional use, or planned commercial district. This is the only planned commercial district property in the entire overlay district. City Council, when they created this overlay and amended it again in 2012, specifically was showing this property would be applicable to these standards. And this is one of the reasons why Kroger's had to amend their plans to meet these standards.
But it says prohibited car wash facilities. in here.
Correct.
So just to confirm, the first we heard about a car wash was in February of 2026.
When city staff received a formal application, that's
Okay.
correct.
Okay, thank you.
What other questions at this time?
If I may, really quick, my understanding is that the first that the city heard was not February 11th when they submitted this. My understanding was that this was pretty well evidenced and the applicant and owner had been in communication with the city for a long time. Maybe I'll have Craig come up in a second to address that. But really quick, to your point, and asking about the references in the code. I mean, we're having to go to page 74 to find a sub-reference to planned commercial district to demonstrate that somehow this applies to green gates. Again, I think the plain language of the applicability section, entitled applicability, says that it references this zoning code. Again, if they meant for it to supersede green text, they would have said any zoning text, all zoning text, this code and green gates, this code and any other zoning text. The fact that it didn't is demonstrative that it wasn't supposed to do. And to the extent that they meant to and didn't, again, I think the legal memorandum and that, again, is the understanding of how that hierarchy works. And there isn't it was specifically permitted back in 2001, based on those definitions, and we believe that those apply. Craig,
Yeah.
just a second, if I may. Yeah.
So,
Craig Van Breen with Wash Concepts. The only point I want to make is, like, we've built 135 of these locations all over the Midwest, and this is what we do. We're pretty good at it. And we're very diligent about how we approach these. So when we're working with the city or working with a landowner, it's been described to us as a by right site. We don't just take their word for it. Our engineers with Kimley Horn, I'm happy to have them testify. Kevin Culp actually talked with Andy Moore, and they said that this was a by right. So those drawings that are produced there, that's probably about $30,000 worth of drawings. We don't do that unless we think that it's a by right site. So when we talk about the ambiguity, and now you have to reference this and reference this, I think the own city's administrator was confused initially. That's what gave Kimley Horn the green light to produce these drawings. And then we heard, oh wait, no, there's this other text amendment that is going to apply here, and you guys are not a by right use, after we'd already done the drawings.
Craig, real quick, when you say by right, what do you mean by that?
That means that it doesn't require a conditional use permit, that our use is approved. There's things that we have to work as far as like building heights and conformance to local ordinances. We work all those, but the use of the car wash itself is approved.
And your engineer, is that Kimley Horn?
Yes. Yeah.
So Kimley Horn, your understanding Kimley Horn was in communication with?
Yes, Kimley Horn was in communication with the city, and I'm happy to have them on a call with the city, whatever the case may be. But they were emphatic that conversation had happened.
And it was a
By right use.
by
And
right.
which, it's a by right use, therefore they've proceeded with their drawings.
So I'd like to just clarify for a moment, because the 2001 zoning code said that that was a conditional use.
And
So
if
it's
I-
not by right if
Well-
it's conditional.
Well, if I may really quick, the text of the green gates says that any use that is permitted by right or conditionally permitted within the 2001 is permitted by right within green gates. The exact language, and I can pull that up,
Okay.
is that,
I think it's page 62.
yes. All of the permitted and conditional uses listed in the neighborhood commercial district, general commercial district, and suburban institution district of the zoning code. That's planned commercial district area. Immediately above that, the permitted uses for each of these areas is as follows. I should have started with that. The permitted uses for each of these areas is as follows. And then it lists out all of the permitted and conditional uses listed in the neighborhood general commercial district and suburban office and institution district. So, under the green gates text, within the permitted uses that are indicated within the planned commercial district are all of the permitted and conditional uses that exist in the GC district in 2001. Green gates doesn't segregate between conditional and permitted use, permitted by right. It says all of those that are there are permitted within green gates. And so that was the interpretation that the owner and applicant were proceeding under, and was apparently communicated by the city.
Okay, thank you.
Any other questions? So I would just say for the commission, so one of the things when I was reviewing this over several days was the very point that we are talking about right now as it relates to the Green Gate zoning text and what we just covered in terms of the planned commercial district area and their permitted uses, and with the exception of the kennels, automobile parking. And so you think about, or I thought about, what is in the Violet Point overlay district in terms of businesses, and maybe not within the city of Canal, Winchester, but other adjoining municipalities. I do believe there are some of those. And so then I go over to the Violet Point overlay district, and my own personal interpretation of that was that this was established to promote quality over quantity and additional development standards for future development that would go into this district. But for me, it was hard for me to understand, and it still is, and I think that's why we're here to decide this ultimately, based on our interpretation of staff and the applicant and their legal representation. Is this an acceptable use at 9875 Greengate Boulevard based on the 2001 zoning text, the Greengate's zoning text, and how the Violet Point overlay district applies into this scenario? And so I just wanted to share that because I think there is, for lack of better terms, I'm not a legal expert, but there's confusion over what potentially applies here and what doesn't apply. And I think the references for me that go back to the original zoning code and the planned commercial district are easy to reference versus going over to the Violet Point overlay district and how that references back or not to the Greengate's development text. So that's my comment. And staff, I don't know if there's anything, Mr. Moore, Mr. Hare, if there's additional comments or that you would like to add to the commission or.
The only clarification I just want to make was, the question was if staff had talked to the owner of Moo or the property owner about it being a permitted use versus non-permitted use. There was one interaction with Kimley Horn within, I would say within 30 days at most of the submittal about submitting for the car wash. And staff had informed Kimley Horn it is not a permitted use. And immediately were correspondence with the property owner wanting to get on a call to discuss it, to figure it out. And the conversation had stayed consistent. It was a prohibited use. So my concern is with the property owners saying that they got a green light to spend money, because these are a full set of plans that had not been verified or vetted. The first time staff had seen any of these site plan drawings was the day of submittal. There was no pre-application review. There was no development text review to make sure their plans were in conformance with any of the rest of the district standards. So I think that there have been miscommunication, from property owner to applicant side, but from a city staff to Kimley Horn to property owner to applicant who's here this evening. And to be totally transparent, I have talked to the applicant about other sites for Moo in the overlay district in the last decade I've been at the city, and the conversation has always been it's a prohibited use.
I've had those same conversations with this property owner multiple times in January, but this was not a permitted use.
Well, and if I may, really quick, I mean.
The site plan that they presented, we had those conversations when we first saw the site plan, that it doesn't meet a number of the other standards of the code as was adopted in the preliminary plan and our other codes. So we were very clear the entire time, and we have all the emails to prove that we were very clear and consistent in our answers.
And I don't mean to suggest any conversation. I wasn't present for that. I mean, I don't know. It's irrelevant for the purposes of the argument tonight and for the legal determination of this board. It may in some context be relevant what was said or done, but the fact of the matter is, what is the interpretation of the zoning code? Again, the plain language of the Greengates indicates what is a permitted use within that. It references the 2001 code. There may have been intention to have the Violet Point apply, but the plain language that this board is required to examine does not indicate that. And the fact that there may be confusion or different suggestions, again, at the very minimum, is ambiguity that must be weighed in favor of the property owner, so.
I have a question, and staff, if you don't want to answer it, I respect that. When we approved a very similar business model with Turbo Wash in the Waterloo Crossing development, I believe 3 years ago. Remind me, was that a conditional use that was approved based on that development text?
Yes. So that was a conditional use based off zoning text, not development text.
It's a straight zone.
That's a straight zone property. This is a planned district property.
Okay, thank you. Anything from your standpoint, sir?
Yeah, I'd like to keep this very short because you've heard from the proper parties. The law department's job here tonight is more procedural to make sure you have the guidance on how this should proceed. But for what it's worth, the law department was in communication with the zoning administrator and reached the same conclusions for the reasons that the zoning administrator articulated tonight. However, you've heard both arguments, and you are the body that is going to be determining what the proper interpretation of the zoning code is based on what you've heard tonight. And I believe that you have received enough information to do so. But any questions really should be to either the appellant or to zoning administrator for their interpretations and arguments.
Any other questions to either party?
No.
Okay, so procedurally then, we'll make a motion, and the motion would be to grant the administrative appeal, and if in favor that staff was incorrect, it's a yes. If staff was correct, it's a no.
I think it would be best to first move to close the hearing and then that.
Okay, I'm just asking questions. Can I ask another one?
Yeah.
Okay, so, and then if the appeal passes this board, they move on to submit a final development plan
That's right.
through this body?
Mhm.
And then if it does not, they have the right to appeal to city council.
That's right.
And if city council denies, they can take further litigation, or if they approve, does the final development plan come back to this body or to city council?
To the first question, if city council were to deny, then they would have appellate rights under chapter 2506, like any other decision that goes through that process. Andrew, do you know the quick answer for the other question?
It would be both.
It would go back to Planning and Zoning Commission for a recommendation to City Council.
Okay. Okay. All right. Thank you.
Of course. Recommend that you move to close the hearing.
So, second,
All right, motion made by Mr. Ritchie to close the hearing, second by Ms. Gooden. Do we need a roll call? Roll call, please.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes. All right. So the
And as
hearing's
far as a
closed.
motion that you make, we recommend moving in the affirmative to grant the appeal, which means you find that the appeal has merit and that you would reverse the zoning administrator's determination. A no vote would be deciding that the appeal does not have merit, and you would be upholding the zoning administrator's determination of the code.
So I'll go ahead and make a motion that we grant what?
I'm sorry, I
The
keep turning
motion.
this off. Motion to grant
Motion to grant.
the appeal.
The appeal. There we go.
I'll second that.
All right, so motion was made by Ms. McDonald, second by Ms. Gooden. Any further discussion? All right, roll call, please.
Mr. Ritchie.
Yes.
Mr. Donahue.
My decision is based solely on the comments I made earlier in this discussion around the zoning text between Green Gates and the Violet Point Overlay District and the reference back to the 2001 zoning text. And in my best knowledge, my vote is a yes.
Ms. Gooden, no. Ms. McDonald
No.
and Mr. Paulsgrove.
No.
Okay, so the appeal is not approved. Okay, so we'll move over to our first application for the evening. Mr. Moore.
The first application on tonight's agenda is VA 26008. The location is 160 Kramer Street. The request this evening is a variance from Chapter 1115.03 subsection A10 to not install a sidewalk with the construction of a new single-family home. Up on the screen is a location of the subject property. This property is located in Lot 1 of Winchester Trace. It is zoned R3 low-density residential. All surrounding properties are zoned low-density residential and consist of single-family homes. This subject parcel is 0.39 acres. It is, again, Lot 1 of Winchester Trace subdivision. Property to the east are all located in Winchester Trace, and properties to the west are located in Catherine Miller's subdivision, which is in Franklin County. So not to make it any more confusing, but this is Franklin County, this is Fairfield County, this is the dividing line, which separates the two subdivisions. The applicant is requesting approval for a variance from the subdivision regs to not install a public sidewalk with the new residential home construction via Chapter 1115.03A10, which states sidewalks shall be installed inside the right-of-way along all streets. When the applicant's plan for the new residential home construction is on the right, their variance letter and statements on the left. They're noting they're requesting the variance due to the existing conditions of the surrounding neighborhood, that neither neighboring properties have sidewalks, requiring one to be a disconnect in the existing infrastructure of the neighborhood. When looking at the criteria for approval, this is really just the easiest slide to keep it on from my perspective. Special circumstances and conditions exist for a subject property. When Winchester Trace was platted in 1989, sidewalks were not a required improvement. The literal interpretation of the zoning code would require the applicant to install a sidewalk in the public right-of-way, and it would not be consistent with rest of either adjoining neighborhood that have both been fully developed. Special circumstances and conditions do not result from the applicant. Granting this variance would not produce any undue privilege, would not create any adverse public health safety concerns, and does not put the property to better economic use, and does not permit a use that is otherwise not permitted. So staff is recommending that VA 26008 be approved as presented.
Questions for staff? Is the applicant present? All right. So this is a variance, so I'll open it up for public hearing.
Mr. Chairman, I move we close.
Second.
Motion made by Mr. Ritchie, second by Ms. McDonald. Roll call.
Mr. Ritchie.
Yes.
Ms. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes. All right, do we have a motion?
Mr. Chairman, I make a motion we approve VA-26-008.
Second.
Motion made by Mr. Ritchie, second by Mr. Paulsgrove. Any further discussion? Roll call.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes. All right, VA 26008 has been approved.
The next application, VA 26009, is for a location at 9669 BC Road. This is for the Violet Township Fire Department substation. They're requesting a variance from Chapter 1185 to widen one of their driveways to 45 feet wide. This final development plan for the fire substation was approved by Planning and Zoning Commission in March. It was also approved by City Council in March of 2026. Since that approval, the fire department has reassessed their site drawings and to match other existing station locations and facilitate what they are considering a safer emergency vehicle exit access drive. They would like to widen this access drive bubbled in red from the approved plans from 25 feet to, the plans show 43.5 feet, but their letter requests for up to 45 feet wide. This access drive is as wide as the concrete that leads to both garage door bays on the building. They're requesting for this access drive widening in case any more than one emergency vehicle needs to exit the building at the same time. They both can do so simultaneously. Would like to see that personally. Sounds like an acrobatic trick, but. So staff is reviewing the application. All the details are the same from last time you guys looked at the application, so I won't get into those. But when looking at the special circumstances and conditions, again, they exist. This is a proposed fire station. The emergency medical service facility is requesting a larger access drive to decrease run times in emergency scenarios. The literal interpretation of the code, which was met previously, limits them to 25 feet wide. Since the prior approval in March, the applicant's requesting to make that wider. These special conditions and circumstances do result from actions of the applicants. The plans have been modified for the applicant to have a higher site safety factor. And that granting this variance would be consistent with Madison Township Fire Station within the city. Their access drive on Gender Road is approximately 55 feet wide, just when looking at that from a plan view. Granting this variance from the applicant would increase the public health, safety, convenience, comfort, and prosperity, as it would be used to increase performance of the proposed fire station with site egress. So staff is recommending VA 26009 be approved as presented.
Questions for staff? Anything the applicant wishes to add on this one? Any questions for the applicant?
Nope.
All right. It's a variance. I'll open it up for a public hearing.
See no rush to the mic, I move we close.
Second.
Motion made by Mr. Ritchie, second by Ms. Gooden. Roll call, please.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes.
Mr. Chairman, I make a motion we approve VA -26-009.
Second.
Motion made by Mr. Ritchie, second by Mr. Paulsgrove. Any further discussion on this? Roll call.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes.
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes. Okay, VA 26009 is approved.
And then the final application is an amendment to final development plan 26001. This amendment includes the widened access drive for the fire department substation. So really quickly moving through this here. The substation is being developed west of the existing Busey Road Park, both owned by Violet Township. The applicant will be extending water from Greengate Boulevard, the line in blue, sanitary from Busey Road frontage, line in green. The last submittal from the applicant did not reference the public water line easement. The applicant has added that to this set of drawings here. The red lines indicate the automatic gates for the private drive that will connect Greengate Boulevard to the front of the substation to the back. When looking at the overall site plan, again, the access drive variance is granted to widen this to 45 feet wide. The applicant does note on this bubble diagram that they added the water line easement, and they also had some private electric tie-in relocation, which is not really relevant for this discussion, but just shows that they're moving that from tying in west of the site to Redwood site to the frontage along Busey Road. The access drive location to the rear has remained unchanged. When looking at the landscape plan, has remained unchanged since March. The building drawings, site plan have remained unchanged from interior floor plan and from the exterior elevation standpoint. And again, on the other two elevations. And the applicant's rendering has more or less remained unchanged. This diagram for the access drive exhibit was never super accurate to begin with, so this is only meant for just a visual reference for the boards. So staff is recommending the final development plan 26001 be approved with the following condition. The applicant submits a signage plan for future review. The prior approval in March was that the water line easement be added. That has since been done, so this is the only condition that remains outstanding.
Questions for staff? That was my question, so thanks for answering it.
Does this have to be a recommendation to council?
This would be a recommendation to City Council.
Any questions for the applicant? Is there anything you wish to add? Okay. All right, so again, motion to send to city council for adoption.
Mr. Chairman, I make a motion to send to city council with adoption FDP-26-001 with the condition.
Second.
All right, motion made by Mr. Ritchie, second by Mr. Paulsgrove. Any further discussion? Roll call, please.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes?
Ms. Gooden, yes. Ms. McDonald.
Yes,
Mr. Paulsgrove.
Yes. All right, so FDP 26001 has been approved.
I do not really have much for old new business, other than just to update that the steering committee for the zoning code update met 3 or so weeks back to review module 1, which really sets forth all the new zoning districts that are being contemplated this code, a lot of the kind of base standards. The steering committee will meet again for modules 2 and 3, so there's one more steering committee meeting prior to the plan coming back to the Planning and Zoning Commission for draft review and recommendation to City Council. We have targeted the consultants to try to get the plan adopted by, what did we tell them, October? So hopefully the second steering committee meeting will happen within the next 30, 45 days. And then we can get something to Planning and Zoning Commission in August for a draft review. Is kind of our timeline we're pushing towards. Thank you, Deborah and Rick, for making those comments on that text. If you have any further comments, feel free to reach out to me. Not saying your comments are more important than other people on the steering committee, but you're going to be implementing the code, so I would like to get ongoing feedback if you guys have any. Did you have anything for old new business?
I've got one thing. Is there something in our code, like if there's a nuisance property for a house that has no windows? Like the windows aren't open, but no windows. So 141 West Waterloo Street, I'm not sure if anybody has brought that to staff's attention.
So I went out and looked at that house. I've gotten one complaint already, and there are windows on the house.
Check the west elevation. It's hard to see.
They do not, but they are cleaning out the house from a lot of debris damage.
Yeah, property maintenance code requires that you have glass in the windows, requires window screens.
Okay.
So it's,
Okay.
we can take a look at it.
Yeah, I have reached out to both the applicant, and I've asked them to get me in contact with the property owner about it already, but I went out and I saw there were windows that had the sashes open on the north elevation and the east elevation.
Yeah, check the west. I mean, I'm pretty sure, I haven't gotten out and inspected it, obviously, but just.
They don't have an active building permit, that's something we'll look into, because they're required if the windows are open to have screens
Okay.
on the windows. So.
Cool. That's all I had.
Move to close.
second.
Motion made by Mr. Ritchie, second by Ms. McDonald. Roll call, please.
Mr. Ritchie.
Yes.
Mr. Donahue.
Yes?
Ms. Gooden, yes. Ms. McDonald.
Yes.
Mr. Paulsgrove.
Yes. All right, timeout 8:13 PM.
Missed a few